Before we resume, can I just say I'm very sorry that the fire alarm interrupted the hearing. I'm particularly sorry because I feel sure that for some of those in the room, to hear the fire alarm would have been distressing, if not frightening, and I'm sorry for that. You might like to know that it was in fact a genuine call, but only in relation to a building which is adjacent to and next to this building. So we weren't actually in any danger, I'm very glad to say. If the alarm were to sound again, which I think is very unlikely, I will rise straight away and we will all leave. So you all understand, if it goes off again, we'll all get out and there will be people outside to guide you to the best ways of getting down to the ground floor and the outside. I think all I'd like to say in addition is I hope that the unwarranted interruption won't unduly undermine what we've been doing this morning, which I think has been very useful. And there we are. Now, Mr. Weatherby, before you continue, can I just say this in relation to discovery, that I may have misled you to some extent. If you thought that we were holding up documents in general in order to provide context, that is not the case. We have been disclosing documents as and when they're ready to go. What's been holding things up is partly relationships with the police under the MOU, which Mr. Millett described,
yes,
and partly the redactions process, which has proved to be fairly onerous because of the amount of personal information that we have to take out of documents for Data Protection Act reasons.
yes.
So I hope that to some extent that may allay some of your concerns.
Yes, well, that's extremely helpful. Thank you very much. May I just pick up a detail on that, and just may I ask the inquiry team to reflect on DPA requests. There was something that was mentioned earlier about the firefighter statements. We would certainly have no difficulty with personal, largely irrelevant detail coming out. The difficulty we would have is that, for example, it was mentioned about the condition or the medical condition of firefighters, and we would say that that would not, there would be a balance there under the DPA, and therefore it's something that needs to be dealt with quite carefully.
Well, we are certainly making every effort to ensure that any information which is relevant,
yes,
albeit personal, remains in.
Yes, that's very helpful. Thank you very much indeed. I was dealing with the issue of position statements, so perhaps
yes,
I can just pick that
yes,
up.
Please do.
I was indicating that we were pleased that the statements had been requested and pleased that they had been in the main complied with and provided to the inquiry. But I was going on to pose the further question that what is the aim of position statements? And our submission about that is that they are there primarily to cut through to the key issues, to assist the inquiry and to assist other CPs in how they participate in the inquiry. And I was making the observation that in almost none of the position statements to date has any real assistance been given to the inquiry beyond the processes and the contractual arrangements. As to key issues, why the fire spread, what caused or contributed to such terrible loss of life. And it seems to us that with one notable exception, that's absent from most of the, from all of the statements that have been received so far.
If I might just interrupt you, I think the reason for that is that I deliberately narrowed the scope of what I was asking for.
Indeed.
Because on the last occasion, people said we can't be expected to lay out our positions without having had full evidence and disclosure. And it seemed to me that as an initial step,
yes,
it was helpful to see the structure of the arrangements, which could be done without any need for evidence or disclosure.
Well, again, with respect, I can entirely follow that.
You can blame me to that, some
well,
extent.
I don't wish to blame anybody, but I wish to take it on to the next stage. And the next stage, now that we have this starting point on position statements, we would very much urge you to consider to take it to the next level. Before I do that, can I just point up that there do appear to be some omissions from the position statements. We raised with the team the fire engineers ex-over. Overnight, I think we've been provided with a letter which has gone to ex-over, and they have in fact been asked for it, but for reasons that may not be important, they haven't yet provided that. But obviously that will be an important position statement to add. But there are also others. The one that we note, we don't appear to have a position statement from Kingspan, who are an insulation manufacturer, some of whose products were present on the tower. And I'll come back to Kingspan in a moment, if I may. So what we would urge the inquiry to consider next is, first of all, to fill the gaps with any companies or authorities that haven't yet provided a current position statement. But we would also urge that there be a second stage to the process. And we previously raised, and I'll do it very briefly because I've previously raised it, that in other processes where liability is to be determined, notably in criminal and civil processes, but others as well, defendants are required in law to assist the tribunal by narrowing the issues. And it's often said that such disclosure helps all sides, including those who actually make the disclosure, because it promotes the interests of justice by honing the real issues. And we say that that's something which is of importance here. But here we're in a process which does not determine liability. It seeks to establish the truth of what happened, and it seeks with some urgency to come to determinations which may prevent unnecessary future death. So we say that there's an even more compelling and obvious imperative for further position statements which not only set out processes and relationships and contractual arrangements and regulations, but in fact what the main participants say did or did not happen, and what they and others did or did not do. As key participants, people who were in the various processes that are under consideration, they're in a really central position to assist the inquiry and others, to speed its progress and to hone the issues and strip away probably some irrelevant issues along the way. Now, if there are sensibilities about the fact that disclosure has only gone some part of the distance, we understand that. And in some cases, there may be legitimate issues which can be raised, for example, the privilege against self-incrimination. But in our submission, let the CPs raise that, because in most cases, that will simply not be something that they choose to raise. So we respectfully invite you to call for a further stage where the corporate and public authority CPs set out their stance on, from their perspective, from their part of the overall picture of what went wrong. And in relation to an earlier submission, we would say that leaving it for openings is a wrong move, because that's too far down the track and would leave the inquiry and everybody else in a position of not knowing until too far down the track. Can I raise, by way of an example of this, going back to Kingspan? I've already mentioned them as being a manufacturer of some of the insulation used in some of the cladding. The CEO of Kingspan has made a number of public comments about Grenfell and the fact that Kingspan's products were used on Grenfell, and has chosen publicly to indicate as much in two significant articles that have been published, and has chosen to say not only their products were used on Grenfell, but their products shouldn't have been used on Grenfell. And it seems to us that it would plainly be of substantial help if people such as the CEO of Kingspan were to direct some of the effort that they're putting into articles and media comment into proactively assisting the inquiry. Likewise with Celotex, again the company that's been mentioned before, another insulation manufacturer. They have adverted to test results and have indicated that there were problems with them, although it's not entirely clear what they say about that. And we would say that in a second round of position statements, they should be asked to clarify that and to set out, for example, whether their products should or shouldn't have been used on Grenfell, what the problem exactly with their products was, and to assist the inquiry in that way. But likewise, the local authorities and the government departments involved, particularly the Department of Communities and Local Government under its new name, we think should be asked to be part of this second round as well. We're not asking anybody to predetermine or preempt your determinations. We're simply asking for them to be asked to assist by putting their colours to the mast. We're simply asking for candour. This isn't a game of cat and mouse with some of these companies and departments. And if they genuinely have no responsibility or accountability for what happened, then it's important that we know that at this stage also. Can I finally move on to disclosure? And I've already spoken. Well, I've dealt with disclosure within the specifics of the expert report, so I won't repeat myself on that. But we say that there is still a large amount of highly relevant material that remains outstanding. And we ask for an unequivocal commitment by the inquiry to disclose the remaining relevant material at the earliest opportunity. We note what's been said about the issues with the Met. We're slightly surprised by some of those comments because we've actually had discussions with lawyers for the Met as well. We hoped that a sensible approach would be taken to the issues between possible future prosecutions and this inquiry. And I'm sure that can be done. But we would say, in the example given about firefighters, that it is difficult to see how the disclosure of firefighters' statements to the inquiry and onwards to CPs for the furtherance of the imperatives of this inquiry, it's difficult to see how that could have any adverse impact on the criminal process. I hardly need to go further than that with respect with somebody who sat in the Court of Appeal and knows the criminal process well. But it's a long time since there were cases where publicity of this sort of thing stopped a prosecution. And therefore we would urge, particularly urge the Met to have a rethink and to adopt a sensible approach to these matters and deal with them quickly. Can I just give a list of some of the headlines that we're concerned about in terms of disclosure? First of all, in terms of phase one. Footage. We have had a large number of still photographs, but we've had little in the way of actual footage. And we would seek from the inquiry an inventory of the footage that is available, and we would seek disclosure of the footage itself at an early stage. Likewise, and by footage I'm including the TV footage that the inquiry may have, CCTV footage, body-worn videos from various emergency services. The footage is going to be key to working out exactly what happened. Following from that, we know from other processes and proceedings that timing of footage is often a difficult issue. We understand that the police have been doing their best to time the footage. We would seek disclosure of that so that we can assist with that. There are various parts of our side of this process, for example, mobile phone records that some of our clients hold, which may allow us to do that, and that's been done in other inquiries and inquests. I've dealt with the documents that have gone to the inquiry instructed experts. Mr. Millett referred to 999 calls. Again, we would urge that those are dealt with some urgency now because of their centrality to the witness statements. And we've heard what Mr. Millett said about the remaining police statements. We're concerned about the firefighter evidence and the commander evidence, and that is expedited. But we're also concerned that the emergency services radio communications are disclosed, because they are real-time records, timed, which show what was happening and the commands that were going down the line to the firefighters in particular. But those would cover fire, police, and ambulance. We have referred in our written documents, and because of time, I won't take more time over giving a list of these. But there are various other documents, largely itemised by the Fire Brigades Union, of other firefighting documents which should be available. And we would urge that those are expedited also. And finally, in this respect for phase 1, we would urge that post-mortem reports are disclosed as soon as possible. In relation to a disclosure more generally, it would be helpful and we would urge the inquiry team to provide us with the inventories of documents that have been provided to the inquiry, because that would assist us to go through and help the inquiry team in terms of which of those areas of documentations are and are not relevant. And we can see no reason from our side as to why the inventories of the documents that are available to the inquiry should not be able to be disclosed. And hand in hand with that, the process that we're told and understand is going on, the meticulous and painstaking process of the consideration of relevance, that must be producing schedules of material which is and isn't relevant. And therefore, like in certain other processes that many of us have been involved with, we would seek disclosure of what would in other proceedings be called an unused schedule, again, for the purposes of us raising issues about that. The two specifics in respect of documentation more generally is documentation and material relating to complaints made. Now, we were told at an early stage that this was an area that the inquiry was concentrating on, and therefore it would be very useful to us to have as much of the complaints material that is currently being gathered disclosed as can be done now. And there's the ongoing issue of the housing files. I reiterate before I sit down that we are all aware of how hard the inquiry team is working. We want to participate and assist in that process, and the matters that I've raised are with that very much in mind. That's all I've got to say, unless there's anything I can help.
Thank you very much indeed. Well, now, Mr. Steen, you're next on the sheet. Yes.
If I can avoid the danger of any repetition, I will. We have to react sometimes to material that is disclosed, and indeed material that has been helpfully disclosed. So taking up the thread of the point raised by Mr. Weatherby of Queen's Counsel, who's just left the podium, where the inquiry can provide an index or insight into the material they are considering at this stage, we can provide some support. So as an example, we were provided very recently, I think overnight, with a copy or a list of the call participants. And immediately, myself working with Mr. Weatherby, we've been able to identify that there are perhaps some gaps. Now, it may be that they are organisations or individuals that are currently within the inquiry's site, but we can now discuss it with the inquiry and therefore provide that assistance where we can. As you know, sir, from our remarks made on the last occasion, we are committed to ensuring that our client group, and indeed all survivor, bereaved and resident core participants, are heard and allowed access to expert documents and support that they need to fully participate within this inquiry. But we also recognise that there are many others who have been affected by the Grenfell Tower disaster, who are living day to day with the consequences of that fire, who live today in tower blocks up and down this country. To an extent, therefore, the core participants, the residents, the bereaved and survivors that we represent, they hold for those other people as part of our responsibility, their responsibility, the duty to make the points that we can on behalf of all those people that live in such conditions. And we know this is relevant because, as examples show us this year, on the 22nd of January of this year, in material published by the Ministry of Housing, Communities and Local Government, they revealed that 3 buildings had finished the installation of replacement cladding, but a further 6 had only just been begun in terms of that replacement. The same report identified 299 tower blocks that had failed safety tests. Only a couple of days ago, the 19th of March, 3/4 of tower blocks in Greater Manchester failed to meet even the current standards. The same date, the 19th of March, cladding on 6 high-rise blocks of flats in Cardiff did not meet the current safety standards. So we say that the people we represent are therefore not only witnesses for what happened to them and their own suffering, but also for those people who live with their families in what are apparently defective blocks. Now, the terms of reference for this inquiry, and I will refer to 2, please, are obviously to examine the circumstances surrounding the Grenfell Tower fire. And A, the immediate cause or causes of the fire and the means by which it spread to the whole of the building. Phase 1 will go into phase 2, and as part and parcel of both of these phases, sir, you will be reviewing at C of the terms of reference the scope and adequacy of building regulations, fire regulations, and other legislation, guidance and industry practice relating to the design, construction, equipping and management of high-rise residential buildings. Now, there are many other terms of reference, but I highlight those 2 for a particular good reason. In order for those terms of references to be fulfilled, you need, sir, the voices of the bereaved survivors and residents, and you need that so that they can be heard and they will be listened to, in order to achieve the end product that we all want, which is to establish who and what was responsible for killing the residents in the Grenfell Tower, and to make sure, through changes in fire regulations and safety, that this never happens again. So, practical steps that take us to that end result. My learned friend, Mr. Weatherby, Queen's Counsel, has addressed the question of disclosure. I won't repeat it. But it may help, having listened to him and thought about the issues, if you take on board this short point. Effective participation requires effective disclosure. So that means witnesses, in their evidence, can speak to what has happened, who they hold responsible, what they had been told at the time of the refurbishment and the like, and what they believe should be done to protect people in the future. Now, to get the message across to this inquiry, there are various measures designed to provide support. Screens to make the giving of evidence less intimidating, live links, recorded statements. There are many measures that we use as common standards across the courts. Yep. And of course, there will be, where required, the provision of interpreters, counsellors and intermediaries if required. Now, effective participation therefore means that this inquiry listens to the core participants and their representatives about the best way to put their voices across. Now, in my written submissions, I was critical of a protocol that has been set forward, the protocol referring to vulnerable witnesses. Now, the protocol appeared to suggest, if you look at it in black and white, that a bereaved survivor or resident witness, in order to achieve some type of support, as an example, screens or video link, might have to have the benefit of a report, a psychological or psychiatric report. I see you nod your head, and I've also been able to discuss...
shake my head.
Well, I see you shake your head, and I agree. I've discussed these matters, and I know that they've been discussed behind the scenes with counsel, and I'm sure it's been therefore discussed with solicitors' inquiry. That clearly has been, and also having listened today to Mr. Millett, Queen's counsel to the inquiry, there clearly has been some clarification provided about this. Now, I've got no doubt at all, that the document I refer to, the Protocol for Vulnerable Witnesses, was drafted and intended to provide support for vulnerable witnesses and to make sure that witnesses are protected and that children can be saved from an ordeal. So we understand that, of course. The danger, though, is that if we look at that, and I'm not going to go through it because it's been dealt with, that the inquiry might have seemed as though it was regarding vulnerable witnesses as almost ending up in some rule-bound, rather hidebound way of being dealt with, and potentially an old-fashioned way, or possibly patrician, approach to young people. One of the core participants we represent provides a good example of the sort of issues that a perception of a barrier can provide. She has a daughter, a teenager, who suffered very badly in the fire, but she, the teenager, wants to have her say. The danger, if we were to look at that protocol, was on the face of it means that we would have to ask you, sir, for permission to speak to her and take a statement. Now, I know that we are going to discuss this with Counsel of Inquiry. We will work out a system. But if we were to explain to a 14-year-old, a teenager, that we need to speak to Sir Martin Moore-Bick about whether we can take a statement, I would suggest that we might get a certain response, the same response that I might give if such a barrier was being posed to the giving of evidence. So I'm therefore very pleased to have heard today from Mr. Millett, Queen's Counsel, who clearly has considered our submissions with care with his team, and that what seem to be apparent hard lines in that protocol are not going to be used as barriers for the survivors, bereaved and residents, core participants. Also, we understand, and having had discussions with counsel to the inquiry, that we will discuss the way forward for the dealing with witnesses that are young people, so that their statements can properly be taken. Progress is being made. The same spirit of collaborative working across this inquiry is also paying dividends in the response from counsel to the inquiry we heard today about access to this inquiry, literal access. Mm-hmm. The discussion that we heard today about support for childcare arrangements is welcome. Issues that relate to time off work clearly needs more work. It is a difficult area to consider, but it is necessarily something that we will need to speak to the inquiry about. So there are still some issues, but they are capable of discussion. And you will, sir, be pleased to hear that your words in opening this inquiry last year, where you said, I'm open to suggestions about how I can obtain evidence from those witnesses in a sensitive and appropriate way, are being given good effect. So, issues that remain. The venue. We hear what was being said today, that this is, it seems, at least at this moment in time, the chosen venue. When we look at what this room provides by way of an opportunity as a hearing room, and if I think about the measures that may be required to provide support for witnesses, there are obvious deficiencies in this arrangement, and there is no doubt about that. The location is also difficult for survivors, bereaved and resident core participants in terms of travel. It doesn't take much thinking to work out that someone that has found their way through the black corridors of a burning building may not enjoy the rigours of going on the tube to this particular area. These are matters that are real, and they affect, if I have my maths right, 667 potential people. That is a lot of people that this affects. So these issues, the question of loss of earnings, the question of this location remains still something we would ask to be attention to. And we were pleased to see that the Mayor's submissions that have been put forward also echo the question at the very final paragraph of whether this is indeed a suitable location. We would ask, though, that perhaps the Mayor's office may be also well placed to provide some consideration if there are any other possible venues that they could consider. Lastly, in terms of the practical arrangements, there is a need to understand that when this inquiry is going on through the summer, through those weeks and months, that there is a need so that our client group, our core participants that we represent, have the ability to speak to us in private. So consultation rooms, desks and the like are not just fancy places for us to do our work, though that would be welcome, but it would in fact be the only way forward when dealing with the large number of people that we represent. And may I suggest the way forward, again, going back to what I've said about collaborative working, is we have a plain and simple meeting about this with Counsel and Solicitor of the Inquiry to discuss the actual practical arrangements. So I've been dealing and have mentioned already the need to make sure that core participants have a voice on the issues that will be addressed by this inquiry. One of those issues I've mentioned is a question of consideration of current fire regulations and what changes should be recommended by the inquiry in the future. The Hackett review is already looking at this issue, and since representation has been confirmed before this inquiry, we have been seeking access to and a voice within that review. Dame Judith Hackett, who conducts that review as chair, does so under the following terms of reference, that following the Grenfell Tower disaster, the government commissioned her to provide an urgent independent review of building and fire safety regulations and their effectiveness. The purpose within those terms of reference for the Hackett review is to make recommendations that will ensure we have a sufficiently robust regulatory system for the future, and to provide further assurance to residents that the complete system is working to ensure the buildings they live in are safe and remain so. Now, I quoted the terms of reference for the Grenfell Tower inquiry, your inquiry, sir, a few minutes ago. And at C, as I repeat only very shortly, that deals with the scope and adequacy of building regulations and fire regulations and other legislation. So we can see when considering the Hackett review terms of reference and the Grenfell Tower terms of reference that there is a lot, if not entirely, common ground between the review and this inquiry. Sadly, the Hackett review is currently proceeding without ability for the Grenfell Tower core participants to make supported and ongoing submissions as to the detail of that review. Now, I want to be clear about this. This is not to say that Dame Judith's team have not spoken to Grenfell Tower residents. That would be wrong to think that. They have. They have had engagement, as I understand it, with specific resident groups, and they have conducted what are called roundtable discussions. What is lacking, we suggest, is specific and detailed access to the Hackett review submissions and ongoing discussions to be able to contribute to Dame Judith's Part 2 report, which is said to be delivered not far away at some time early this year. And let me make it clear what we are actually suggesting is required. That is funding for core participants to have their views collated, advice from experts who are funded, so that they can make equal submissions in equal detail to the Hackett review as are being put forward by various representative bodies and companies and industry insiders who currently populate the Hackett review committees. That is required so that the Grenfell Tower voice of those residents that we represent can be heard, that voice which has become more knowledgeable and more compelling through their ordeals. On the Hackett review committees, there is no mention of any Grenfell Tower group or representative expert who is putting across the viewpoint of the survivors. But there is plenty of representation from industry and local authorities across all of those committees. I'll mention some names of those committees, of those representatives in a moment. We're not in any way suggesting that the review is being conducted in bad faith. We're not suggesting that those representatives are not doing anything other than trying to put forward what are responsible views. But if there is not a voice in relation to that particular aspect of her review, then there is a danger of matters being lost. So I mention this so that we have an understanding. There are various working groups, effectively subcommittees of the Hackett Review. They have different names. The Golden Thread Group, which is really, as I understand it, designed to provide the way forward in the future. That is populated, we would understand, of course, by the National Fire Chiefs Council, Local Authority Building Control. The Construction Products Association is there, but little representation, it seems, by way of residents. Regulations and Guidance, chaired by the Construction Products Association. And we can go through these committees, of which there are, I think, 7, maybe it's 6, and there is not, at the moment, a full representation. There is a Residents' Voice Committee. That is Working Group 5, and that is chaired by Mr. Hartley of the Tenants and Residents Organisations of England. So there is a particular committee that is designed to deal with residents' voice. That, though, we suspect, is not going to be sufficient to understand and take on board the voice that is required across those committees, supported properly with expert advice where necessary, so that a contribution can be made from those people that have gone through this and either lost loved ones or survived. We know that that review will be feeding its findings into this inquiry, not because it is anything other than plainly obvious, but because at page 14 of the first part of the Hackett report, published in December of 2017, paragraph 1.2, the following is said. As set out, this is by Dame Judith, as set out in the review's terms of reference, published on 30th of August, this review is running in parallel with the work of the Grenfell Tower inquiry. The review is independent and covers the system of regulation for all high-rise residential buildings. It will, however, provide useful background and input into the inquiry. There is an urgent need, therefore, for our Grenfell Tower Core participants to have a real voice within the next section of the Hackett report. This, we suggest, means much more than a relatively casual conversation, no matter how well meant, with some residents or residents' association. There is a need, we suggest, for residents of tower blocks, and in particular our core participants, to let it be known what they would think of the priorities that are being set by the Hackett report, and whether they go far enough in suggesting change for the future. Now, we've opened our discussions with the Hackett Review team after, of course, we have properly been enabled to by the grant of funding through this inquiry and the formation of our teams. And we have been invited, I think overnight, to have a half-hour discussion with them over the next week. We are going to obviously take up that invitation, and we will be discussing these matters with them. Again, I have no doubt whatsoever that the Hackett Review team is working hard to make recommendations that may change the landscape of fire regulations in the future. And it would be difficult, if not impossible, to criticise Dame Judith harshly when she has already said that the current system of fire regulations are not fit for purpose. Nevertheless, a mistake may be about to be made here. Now, we saw the dangers of mistakes being made on consultations during the process for the refurbishment of the Grenfell Tower. Now, residents were consulted about the potential refurbishment. Those consultations were to extol the thermal efficiency of putting cladding on the Grenfell Tower. Sadly, no resident was told that the thermally efficient cladding could also be a thermally efficient fire risk. On the 14th of May of 2012, at the Mermoz Tower in Roubaix, France, the fire spread through the aluminium polyethylene composite cladding, a second-story fire origin leading to rapid vertical flame spreading to the top of the building within minutes. On the 29th of May, so something like 2 weeks later, at the Grenfell Tower evening meeting to discuss the refurbishment, there was a discussion about cladding. This was one of a number of consultations about the refurbishment and about the apparent advantages of cladding. Despite the fact that this was only shortly after a cladding fire had taken place, there were no reference to safety issues concerning cladding at that time. The Hackett Review has also attracted some criticism from the Communities and Local Government Committee, where the suggestion made by that committee, perhaps understandably, was that in the future it might not be right to continue to permit the use of combustible materials on high-rise buildings. A sensible suggestion from that committee, and one that we obviously agree with. So in the future, when phase 1 of this inquiry is complete, and the Hackett Review will be complete as well, that report will be fed into this inquiry. We need at this stage to make you aware that there is a danger in the Hackett Review not having the ability to receive the properly supported views of people from the tower and the outside area. There is a danger that their voices will be lost in relation to her report. We will argue throughout this inquiry that residents of tower blocks can be trusted to have access to all information they need so that they can make choices. We will argue that the system of fire regulation in this country must be viewed from the perspective of residents and that their voices must be heard as to what level of risk, if any, they will be prepared to live with and to bring their children up within. If we leave aside this question of access into the report being drafted by Dame Judith, then there is a danger that a report will be provided to this inquiry within which they will not have had a say. And I've got no doubt at all that there will then be submissions being made on the basis of that report. Well, you've heard what Dame Judith has said. We can hear it ourselves. We can hear the reference to the page numbers as it would be delivered to you, sir. And it will have accepted or become accepted into the industry status quo the recommendations she is being made. Now, we don't need to dwell too long, but let's remind ourselves of what happened the last time. Little more than bare consultation was paid to Grenfell Tower residents. We ended up here. My brief today and targets have been to address witness care and practical engagement with core participants. This is directed at practical engagement with the inquiry issues as set out within your terms of reference and mirrored by those within the Hackett Review. It seems we are making progress. It's tempting, and my notes in fact say, don't regard us as a nuisance. Please use us to give this inquiry the best chance of the best possible outcome. Well, we are certainly seeing in our engagement with Counsel to the Inquiry and his team and Solicitor of the Inquiry that we are making progress in that way. But this is not something that we can do in one go. And so when I ask you next, would you please be prepared to give Dame Judith a ring? We ask it in all seriousness. We invite you to discuss with Dame Judith and her team what we can do by providing practical engagement within that review, and we need to do so now before the opportunity is lost. So those are our submissions.
Thank you very much. That's very helpful. Now, Mr. Maxwell Scott, I think you're next on the agenda. I'm sorry, it's a bit tricky getting in and out of your seats, isn't it?
Yes, Mr. Chairman, my name is James Maxwell Scott and I represent the Royal Borough of Kensington and Chelsea, instructed by DWF. There is nothing in my written submissions which I need or wish to develop further. However, I hope it may assist if I comment very briefly, and I do mean very briefly, on some issues which have been canvassed this morning. And I propose just to stick to three, and they are disclosure, the inquest function issue, and the phase 1, phase 2 split.
Yes.
So, taking those each in turn, as to disclosure, as I stated at the last hearing in December, we are sympathetic to submissions being made about the importance of the disclosure process being transparent and of the need for participation to be informed by disclosure in order for it to be meaningful. If I turn then to the inquest function, we respectfully agree that it would be undesirable for there to be a need for inquest to be held after the inquiry has completed its work and reported, and in particular, undesirable if any such inquests required the bereaved survivors or residents to give evidence again. So we leave it to you and your team to decide how best to achieve the sensible aim of minimising the need for inquests to be held in future.
Yes, all right, thank you.
And then thirdly, on the phase 1, phase 2 split, my position has in substance not changed from the last procedural hearing. All core participants would benefit from as much certainty as possible about which issues will be addressed in the phase 1 evidence, which will be addressed in the phase 1 report, which may in some instances be a different matter, and whether the views expressed in the phase 1 report will be provisional or final. However, we recognise that there will inevitably be a need for flexibility, and we have complete confidence that any changes in plans will be handled in a way that is fair to all core participants. So unless I can assist on any other topics, those are my submissions today.
No, I think not, and thank you very much for making your position clear on those.
Thank you.
Thank you. Now, Mr. Garros?
Yes.
That's it. That's fine. Take your time.
So good afternoon. My name is James Agros. I represent the Kensington Chelsea Tenant Management Organisation. I'm here today with Richard Crockford from Kennedy's Law and Alice Jarrett, who was here on the last occasion. So we made 3 brief written submissions,
Yes.
which were given to the inquiry on the 7th of March. And I know that all the core participants have had a chance to see all of those submissions. And so we don't intend making any lengthy further oral submissions today. Of course, if there is any matter which has arisen as a result of the oral submissions or indeed the written submissions which have been made by the parties this morning and this afternoon, we are more than happy to address those and answer those as best we can. So far as the scope is concerned, and again very briefly, and in relation broadly to the question raised by Mr. Friedman as to whether the inquiry should address inquest-type questions, as we have said previously, the TMO is keen that the inquiry examines the causes of the fire as thoroughly as possible, consistent, of course, with your statutory function under the Inquiry Act 2005 and convention law. So to that extent, we certainly support the submissions which were made earlier today. So far as disclosure is concerned, we hear what has been said by a number of the parties this morning in relation to disclosure. Of course, the TMO seeks to continue to assist the inquiry by providing full and frank disclosure as and when required. Indeed, so you know that we have provided a very large number of documents already throughout the course of this inquiry. Those are our submissions, unless I can insist on a particular point.
No, I don't think so, thank you. I mean, I've read what you say in your written submissions. You had a question about witness evidence and whether it would be restricted.
Yes, I
I think the answer is probably not, but I'd like to keep things open for the time being.
Yes, we addressed the question of witness evidence in terms of BSRs and the firefighters, and sought to, we hope, make some effective distinction between the type of issues which might be dealt with in phase 1 and those that might be dealt with in phase 2. We appreciate that there is liable to be some crossover, but so we've made the submissions and we hope that there is some effective way to ensure that the witnesses give evidence only once but in a way which is consistent with the phases as you have articulated them.
Yes, I mean, I would envisage that we would not seek to shut out any witnesses' evidence whenever it's taken. We might have to bank it for phase 2, so to speak, if it was clearly phase 2 relevance.
Yes.
But that wouldn't matter, would it?
No, I don't think it does, sir. I think a good example might, for example, be complaints. For example, that a complaint was made is likely to arise in phase 1, to some extent at least. The way in which the complaint was dealt with is more likely to arise in the context of phase 2. So there may be some distinction along those lines.
Yes, all right. Well, otherwise, I don't think there's anything I need to detain you for, is there?
I don't think so. Thank you very much.
Thank you very much indeed. No, Miss Studd's here for the Mayor, is that right? Yes, hello.
So I am Anne Studd. I appear on behalf of the Mayor of London.
Yeah.
I'm instructed by solicitors Jonathan Lloyd and Anna Concliffe from Transport for London. So I don't intend to repeat, obviously, what's been written. But can I say this, that in order for this inquiry to confidently fulfil its terms of reference, the Mayor would endorse the representation that's been made by others that effective participation from the bereaved survivors and residents is essential, and that this should be a priority in all of the decision-making processes adopted by your inquiry. And we would urge you to proceed with as much transparency as possible in order to allay any suggestions that the process is ignoring the needs of those most affected by these events. We welcome the concession in relation to the position statements because they've now been disclosed on relativity, and we also welcome the very careful consideration that has been given in relation to pen portraits. These are clearly very positive steps, and from listening to the representations made this morning, they've obviously had a profound impact on the confidence of those most directly affected. Can I just say one or two things about these pen portraits? We would urge you, sir, to take account of the submission of Mr. Thomas QC in relation to the pen portraits and the way that that evidence is likely to be given. We would suggest perhaps that consideration should be given to a formal opening of some sort of the inquiry to take place in advance of those pen portraits in order to give appropriate formality, dignity and respect to that evidence before it is given. And in relation to what Mr. Steen has said this morning, it may be, this afternoon rather, it may be that those hearings could take place in a location closer to the site of the Grenfell Tower, because it's likely to be an isolated part of the evidence. And it may be that in that way, more of those wishing to attend and support those people who are going to give evidence before you could attend and provide that support. Moving to venue, obviously the Mayor of London will assist in any way he can in relation to venues. It sounded from the submission made by your council this morning that fairly extensive inquiries have already been made. But obviously there only needs to be contact if
yes,
you think that we can
venue
assist.
has been a live issue for a long time,
Yes.
and I wouldn't like anyone to think that we have not been doing our best to find somewhere else. A great deal of time and effort's been employed on that, but
Yes.
for all sorts of different reasons, for different locations, they've not turned out to be suitable. If the Mayor's got something to offer us, well, of course we'll consider it.
I'd love to be able to pull that rabbit out of the hat, but certainly we can have communication with your team and see whether or not
Yes,
there are any alternatives. Can I say this? I think the assistance that your council gave this morning in relation to transparency on what inquiries have been made may be very, very helpful to those for whom this has been a very significant issue. And lastly, the Mayor would support the representations from various legal teams in relation to the provision of assistance. Certainly in your protocol, you seem to identify vulnerable as being much wider than that provided for under Section 16 of the Youth and Justice and Criminal Evidence Act, which of course is restricted to criminal proceedings in any event. So your discretion is much wider than that. And we would also support the submission that any anxieties felt by witnesses should be alleviated as far as reasonably practicable.
Yeah.
There is an inevitable anxiety in anybody who has to give evidence in relation to these proceedings.
Good. Thank you very much indeed. Mr. Sturman. Sorry, it's a bit of a walk, isn't it?
Good afternoon, my Lord. I'm Jim Sturman. I act for CEP Architectural Facades. I'm here with Helen Bourne of Clyde & Co. And you've got our written submissions, and
Yes,
everybody
thank
else has. There are a few things I'd like to develop, however, because we are concerned about the time from the disclosure of the underlying material in the experts' report. We accept and acknowledge and wouldn't for 1 second seek to deviate from the position that cross-examination is for you in the first instance and your team. But it is obviously very important that we are in a position that if we're going to have any input into the expert evidence, that we are up to speed as soon as possible. Disclosure was one of the items we had illustrated, and I'm going to try not to repeat what's been said by others. I'm certainly not going to speak to my note. But the experts for the inquiry have had 5 months and have been on the site. Mm-hmm. When I arrived this morning, I was told that our experts couldn't go on the site because it's currently too dangerous after the winter. So I was very relieved to hear that there are, in fact, visits being made available. And if that's only to the exterior, and I've misunderstood what is now possible, we are concerned that if our expert cannot get in to the site, we're at a huge disadvantage, and these proceedings, of course, have to be fair to all. So I will liaise with the Metropolitan Police today before I leave the building.
That's the answer, isn't it?
Yes.
I mean, as you've heard already, the police are willing to make the site available, providing it's safe for them to do so.
Absolutely.
And I think it's a matter of speaking to them and finding out what arrangements can be made.
Absolutely, and we will do that. And whenever we're all together or whenever we speak on the phone, progress is made. But we are concerned about disclosure and how that affects timetabling. Mm-hmm. Because if we receive this material shortly before Easter, and it's going to be very substantial, and at some point our expert needs to go in, it is highly unlikely in reality that on the 4th of June we will have an informed opinion from our own expert. And I was a bit concerned when I heard Mr. Millett conclude this morning with a proposed timetable where the experts would very early in the proceedings give an oral and visual presentation of their conclusions so far. We wish to reserve our position on that because it may be that would be unfair in all the circumstances. We wait to see what that proposal is.
Yes, I don't think what he has in mind is that we would take the expert evidence in the conventional sense at that early stage, but the reports will obviously be out there, and I think what we have in mind is that they might simply receive a sort of oral elucidation of what's in the written report.
If it's in effect no more than an opening, then any unfairness can be cured by the experts being called to give their evidence later.
Exactly.
And we had indicated that in our written submissions that we felt that the experts should be called late in the day, and we would respectfully submit that if we could be assured that the experts weren't going to be called until July at the earliest, we would hope to be able to work to that. And that would no doubt help the concerns that were shared at paragraph 20 of Mr. Mansfield and Mr. Thomas's joint submissions as well, about the time to get on top of that aspect. But it'd be very unlikely that we would be able to deal with any expert evidence ourselves in any opening that we dealt with. One final point. I was approached by one or two others, including counsel for Ryden, who does not have a speaking slot. And I said I'd raise this. in the course...
You're the subcontractor, are you?
well, on this occasion, it's a reversal of roles, yes. Mr. Millett seemed to be suggesting that one of the experts now might well be trespassing from what was going to be her report that dealt Miss Lane. Phase 1 was a preliminary report on identification of fire protection measures, but now her evidence appears to be trespassing into Phase 2. That would
she may give evidence that's relevant to both phases.
Absolutely.
And there's no reason, is there, why we shouldn't use that part which is relevant to what we want to decide at Phase 1 and leave the rest to help us on Phase 2.
Absolutely. The point that I think we all need to make, though, is, and I make this on behalf of Ryden, is that might make our experts take still further for us to make a decision as to whether we're going to be making any application to cross-examine through Mr. Millett or indeed through yourself, sir. So we submit, if the experts could be timetabled for July after all those directly affected by this tragedy had given evidence, that might solve all these practical problems.
Yeah, well, that's a very good point. Thank you.
I've got nothing else to say.
Right, thank you very much indeed. Mr. Walsh is here for the LFEPA, yes. Yes.
Good afternoon, sirs. Stephen Walsh, who, as you know, together with Sarah Lefebvre, appears for the London Fire Brigade, which is an easier way of saying the longer version of the LFEPA. Sir, you have our written submissions. They are very brief, and obviously I've no intention of repeating them now. Suffice to say, given the obvious and perfectly proper concentration on disclosure issues this morning, the LFEPA, the LFB, has been carrying out a very thorough and timely disclosure exercise from the earliest point last year. It continues to go on. It's being done with expedition and is thorough, mostly through the MPS, but also with GTI as well. And obviously that is continuing, will continue into the future. I just want to confine my submissions to one issue really here, and that concerns the continuing concern which the Fire Brigade has for the welfare of its staff. That is to say, of course, firefighters and others who may be required to give evidence during the inquiry. We have discussed matters with the Fire Brigade Union and with the Association of Fire Officers, and where appropriate, we will liaise with both of those bodies to provide the best support we can, to include counselling both before, during and after the inquiry in the evidential section. Obviously, that contact will be restricted only to those obviously permitted matters, including familiarisation and counselling and so on. But we need the help and support of the inquiry itself, if that support to firefighters is to be provided with the greatest effect. And what I mean by that, essentially, is that the LFB understands and takes it to be, well, we've been assured of this and we entirely accept it, that the maximum possible prior notice of the inquiry's intention to call witnesses will be given, so that a range of measures can be put in place to assist those witnesses. It's quite important because there are, as well as providing support and care, there are complex arrangements which have to be put in place with taking people off the run. We don't have to close fire stations and so on. And we trust and know that we have the full cooperation of the inquiry there. But just turning to something which Mr. Steen touched upon about a few moments ago. The LFB say that in common with the essential provisions and obviously necessary provisions made for the bereaved survivors and residents who give evidence, each firefighter witness, we take it, is to be afforded the range of measures provided for in the inquiry's protocol for vulnerable witnesses, where necessary. We entirely understand the position there. There's very little else that I need to add, to be honest, save for one matter. And for what it's worth, the LFB also agrees that it would be undesirable, if it can be avoided, and that's the issue we know, for inquests to have to be held in addition to these proceedings, if only, and there are any number of reasons, because it avoids the necessity of witnesses, bereaved survivors, residents, firefighters and others having to give traumatic evidence twice. But unless there's anything else I can assist you with, sir.
Just help me with this. Do you envisage that the LFB will be discussing with the firemen and liaising with us about who needs what sort of special measures?
Yes, there are a number of difficulties about that. We have been asked, for example, to be able to indicate which firefighters or employees are experiencing psychological difficulties or are going through counselling. Now, the problem with that is that counselling has been provided to firefighters and that offer has been taken up. But we're not in a position to identify who has, because there is a confidentiality issue with those providing that care.
Well, I see that. I think all I'm really seeking is some sort of confirmation that either you or possibly LFB, FBU, I don't know who it's going to be, but will tell us when the time comes what sort of measures you think any particular firefighter will require, because of course they're not going to be giving evidence next week, and in a couple of months' time things may not look quite the same.
Well, exactly. So things do change. What is envisaged, we hope, is that sufficiently early notice of identified witnesses will be given. We will know who they are. We can then speak to those witnesses. We can directly ask and ascertain if they're prepared to say if they are experiencing difficulties, speak to them about those difficulties, and then identify with them, giving them the choice and the option, what are the appropriate measures for them. We would then come back to the inquiry, to GTI, and discuss those, and I imagine it is envisaged that we would take it further. But it is crucial, obviously, that as much notice as possible is provided,
yes, of course,
so as to be able to achieve that end.
I understand that. Good, thank you very much.
Thank you very much.
Mr. Seward, you're next.
Good afternoon, sir. I represent the FBU and the interests of the firefighter members who are interested in the outcome of this inquiry. I'm instructed by Gerard Stilliard at Thompson Solicitors. I agree with the bereaved and survivor residents' submissions and won't go through them individually. I see a sigh of relief. And please just take it that I support those. They are at the heart of this inquiry. I would just add this, that from my own practice, and I'm sure reflected in your own experience, it is particularly difficult to represent any aggrieved and hurt individual, but to represent so many of them presents acute and special problems. And I think we are all very fortunate with the high quality of representation that the bereaved and survivor residents have got. And should, as Mr. Steen offered, take full advantage of that to make this inquiry a success. So I'm hoping that the building of trust and confidence, which is obviously underway, is going to be a two-way process. Extending that a little bit, firefighters, as I said on the last occasion, are people too, and they have also been traumatised. The FBU is in discussions with the LFB, the police and FOA to support firefighters through this process. This is a very anxiety-raising process coming to give evidence at this inquiry. I endorse what Steve Walsh has said in that context about the welfare of firefighters, and the FBU is trying and will continue to try to work with the LFB to that end. There will, of course, be some firefighters who want to see either the LFB or the FBU, but not both. And we certainly hope to cooperate by advising the GTI team if there are any special measures that appear to us to be required that haven't already been picked up. As Mr. Walsh said, things do change. It's a dynamic process. Louis Brown, QC, who represents the Fire Officers Association, has been kind enough to say he agrees with all my written submissions. And
yes,
I've
he
raised...
did provide something in writing, but you're right, he pretty much adopted what you'd said.
Yeah, and I'm very grateful to that, for that. We've also been able to discuss a few additional points that have arisen today, and save that he hasn't been able to take instructions on all of the detail, he's advised me that he supports what I'm about to say on those matters as well. Of course, I might not say it right, and it's up to him in a minute whether he does. So I won't repeat our written submissions, but I take it that you've read those.
I have, certainly, yes.
What I'd like to do is to focus on a few points. Firstly, firefighter witness statements. Then I want to move on to clarification needed on some of the disclosure. Then on to timetabling. Then on to Article 2, and then toxicity, and finally a few points about the evidence that the FBU intends to adduce, and to ask about synchronizing timings. We've been given a lot of footage, but we haven't got any synchronization of the footage.
Right.
So dealing with, first of all, the firefighter witnesses statements, I endorse what Mr. Walsh says. We do need the list of firefighters whom the inquiry intends to call as soon as possible. It appears there are 108 or thereabouts firefighter witnesses. By firefighter, I mean also control staff and
yes.
fire safety department officers. If I call them firefighter witnesses. 108 whose statements may go on the record. That's obviously an awful lot to read. We also wish to read the other ones that a decision has been made not to go on the record in case we want to make a submission that they ought to. So we ask that the FBU be shown all of the firefighter witness statements taken by the police so that we can address those points. There may be some that we think ought to be called that the GTI team haven't decided to call. We ask for disclosure of those witness statements as soon as possible, because really at this stage every day counts. It's an enormous task ahead of us in April to try and read all of these on top of all of the disclosure and the experts' reports and so on.
I think you can take it that we're anxious to get them out as soon as we can, but there are certain practical difficulties which Mr. Millett alluded to.
I understand that, but it seemed from what he said as though there were several tranches that were ahead of others, and if it's possible to do it in a staggered form, then there's no reason to keep us waiting for it all when we could get going on some.
Yep.
The FBU takes the view that we have to meet with as many of the members of the FBU who have given statements to the police and whom it's intended either to put their statement on the record or to call them as witnesses. I've set out the purpose of those meetings in paragraph 2G of the written submissions. We will prioritise those.
I think I read this.
Yes.
And I think you may need to think a little bit about G3,
Yes, indeed. I mean, we
Because-
have thought about G3.
You heard what Mr. Millett said earlier about the need to let the witnesses stand as witnesses,
Yes,
not witnesses,
absolutely.
rather than FBU members.
Indeed, I had a very long conversation with Mr. Millett yesterday.
Oh, good.
It lasted about an hour and a half, and he did make several references, including Section 35(2). We have Section 35(2) very much in mind.
Good.
We also have our professional obligations to this inquiry as lawyers and to our clients. We have all of those obligations in mind. And there is absolutely no intention on the part of the FBU to distort or alter any witness statement. We can't anyway. The witness statements have been given to the police. They're not going to be released to us until they are already signed off. There's absolutely no question of the FBU being involved in any such process. All we seek to do is to have the opportunity for those of our members who are going to go through the ordeal of giving evidence in a public inquiry to have any points of clarification that arise on their witness statements put to them in a meeting, a private meeting, so they can have the opportunity to clarify those points without being on the witness box.
Well, we're not going to get into a debate about that in detail this afternoon, but I do urge you to think very carefully about
We have, and what we
how far you
propose,
can go on that, in that
we
respect.
have thought of it. What we propose to do is to give safeguards. We've already offered both the police and the London Fire Brigade the opportunity to sit in on those meetings. For reasons which we understand, the police and the LFB are loath to go down that road. That's a matter for them. They have both signed a memorandum of understanding. The FBU is not a party to that memorandum of understanding. We have a different concern here. Our concern is for the welfare of the witnesses, and that's set out in paragraph 2G, and also to help them to give their best evidence. We want to clarify points of misunderstanding, not to alter evidence, certainly not to distort it. May I explain that anecdotally, and of course all the information that comes to me comes anecdotally at the moment because we haven't had disclosure of any witness statements. But anecdotally I am informed that firefighters who have given statements to the police have been unhappy with the written statement that is the product of that rather lengthy video interview. So what they undergo a video interview with the police, which is a very lengthy discussion, which is recorded. Then somebody has to condense that into a witness statement. And in the condensing of it into a witness statement, there's a lot of scope for misunderstanding. And we've heard anecdotally that firefighters are not always happy that the person who's condensed it, summarised it into a witness statement, has understood what the firefighter meant to say or did say in the course of the interview. So it's largely a question of understanding the nuances of firefighting and giving the firefighter an opportunity to deal with points of clarification without standing on the witness box in the public glare. Now, the safeguards that we have in mind are firstly to give a firefighter a handout which, and take them through it, which gives a structure and everybody can see it. We can serve that on the police, serve it on the GTI inquiry, serve it on the London Fire Brigade. It's not yet finalised. It does need to be finalised. It will be quickly. To have to only ask open questions of the witness with a view to clarifying any points that we consider need clarifying. We will digitally record every such meeting and preserve the record so that anyone can interrogate what was said in the course of the meeting. That, of course, will include the police. And the guiding principle will be to clarify, not to contaminate. Very sensitive of that issue. The whole meeting will be conducted by a solicitor, from Thompson's. And the end product of the meeting will either be nothing at all, because there's nothing to add, or there'll be a further witness statement which will be given to the police and the GTI team, or there'll be questions for us to submit to council to the inquiry 5 working days before the witness goes into the witness box. So those are the, if you like, the substantive witness evidence end products. There will be other end products, as is clear from what I've said in the submissions. We can assess whether any of those witnesses may be ill or vulnerable, consider any special measures that might be needed, offer them reassurance and advice about any claims that they may have, answer any of their questions, introduce the teams, let them know what support's available, and so on. So we consider that we cannot represent the FBU or the interests of the firefighter members of the FBU who are involved in this inquiry process without meeting them. So that's what we intend to do, but please accept from me that we are acutely sensitive of not only Section 35(2) but all our other professional obligations. And this will be an open process which will be subject to scrutiny.
All right.
That brings me back to the trust and confidence point I made earlier. I do ask you to have trust and confidence in us in this part of the process. Moving on, clarification is needed on disclosure of the transcripts of 999 calls. Mr. Millett has explained that there are 2 types of disclosure. One is to the caller and those who were in the caller's presence. And type 2 appears to be broader. It appears to be all CPs, if I've understood that correctly. And it may be that disclosure to all the CPs answers my point, but I just want to clarify it. I would hope that one of those present would be the control room operator who had received the call, so that in every case where a transcript is provided to the person who made the call, that it would also be provided to the control room operator who took the call.
Yeah.
Timetabling, a big ask for flexibility. Mr. Millett has explained how much work is involved after receipt of witness statements by the GTI team. It's daunting to contemplate the amount of work that's involved by us, I'm sure everybody in this room, on receipt of the information that's going to be coming our way at the end of March and into early April. So there may well be slippage. It's highly likely that there will be. And so when the deadline is given of 18th of May for opening statements, I would ask that there be flexibility on that. I appreciate that the team, the GTI team, have got to read and digest opening statements. But I think we're going to need every single day to get through the workload that we've got.
Well, you do your best to get them in by the 18th of May, and if you have difficulty, explain what it is.
I think that's that is entirely foreseeable that there will be such difficulties.
Oh, you shouldn't be too pessimistic. I'm sure if you put your mind to it, you'll be able to do it.
I think a bit of realism goes a long way, doesn't it? Right. And I do know myself. Okay. Article 2. Broadly, the FBU supports the desire to avoid duplication. Just one point to add. Mr. Millett made the point that the Chief Coroner hasn't asked the chairman, sir, to answer the inquest questions. And I have no idea what discussions have gone on between you and the Chief Coroner. But all I would say is it would be a travesty if the opportunity was missed to have those discussions while there's still time to involve the Chief Coroner if he wants to be involved in the Grenfell Tower inquiry. and there's all sorts of possibilities which are way outside of my responsibilities to even mention. But for example, sitting on the panel is one possibility. Moving on to another issue, toxicity. I feel a little remiss because Mr. Mansfield did raise this at the last hearing, and I didn't then realise the significance of it. But it has been raised again today, forcefully, and of course suddenly the penny's dropped. It's not only going to be relevant to the cause of death in some cases, and to the effect, if any, on the wider environment, but it's also going to be relevant to the question of the long-term health effects on those who were in Grenfell Tower exposed to poisonous gases, and they will have very real concerns about how it's going to affect them. It's a developing science, this field of cancers and contaminants and the effect of inhalation of toxic gases. It's very much an expert field, and we strongly support the application, or at least the submission in favour of getting expert evidence on that. Mm-hmm. An expert was asked on on an unrelated matter about the effect on firefighters of smoke inhalation, and she offered the question, were the firefighters from Grenfell Tower blood tested in the immediate aftermath? And of course, I don't think anybody was alive to the possibility of blood testing immediately afterwards, but at the very least there's a recommendation there for the future. But it may yet be possible, and only an expert would be able to say, whether the long-term effects can be gauged by reference to the work that was going on, the use of BA sets or the non-use of BA sets, and the inhalation of gases. Moving on, the FBU intends to submit witness statements to you, sir, for Phase 1 from the following witnesses. Matt Rack, the General Secretary of the FBU, he intends to deal with recommendations, but he's not going to deal with all of them. There have, as you know, because we've submitted that schedule, been an enormous number of recommendations made that may have a bearing on Grenfell Tower in the past. Matt Rack's going to concentrate on those which he considers are highly likely to be relevant to Phase 1 of Grenfell. Steve Wright is going to give a witness statement on the progress of the FBU investigation into this serious incident. And Dave Sibbett is the FBU expert on fire safety, and he'll give a witness statement on those aspects that appear to fall within the issues that you've identified he wants to look at. So it won't be the whole of the Phase 2 issue, it'll just be those issues that are relevant to Phase 1. Right. Finally, synchronizing timings. The footage is really helpful, particularly TIC camera footage and so on, but it's very difficult to put it into a context without a means of synchronizing the times. So I understand that the LFB have told me that 2 of the TIC cameras are about an hour, well, exactly an hour out. So now we can work that out. But that sort of information should be available to all core participants so that they can readily see the significance of any footage that they've got and time it. Work must be going on with that with the police. Work must be going on with that with the LFB. I would ask that if the inquiry could, with each piece of footage, I think Mr. Weatherby has already asked for a schedule of footage. If that schedule could include any adjustments on time that need to be made, that would be most helpful. In that context, because of the amount of work that's got to be done, I do ask that core participants be given lists and indices in a Word or other processable format, because we will also need to use that list to make comments and to make suggestions. And to have it in PDF form is a great limitation.
Yes.
Thank you very much.
All right. Thank you very much indeed. Now, Mr. Lissack.
Mr. Chairman, Mr. Lissack asked me to tell you or inform you that he does not wish to say anything.
Right. Well, he must have changed his mind since he asked to be put on the speaking list still. That's all right. We shan't complain.
No. And therefore it leaves me to make
Yes,
what
thank
are
you very
listed.
much.
So may I please be allowed to interrupt just for a moment, because Mr. Millett entirely forgivably has forgotten that during the midday adjournment I did mention to him that with your kind agreement I would like very, very briefly to address him, please, commenting on something that was said this morning of which we had no notice, of which there was no indication in writing.
Yes, yes, of course.
This
Would you like
is
to
a
step
special
up to...
application, Mr. Hockman, is it?
Correct.
Right.
We need 2 minutes.
You need to come here to do it in that case.
I'll vacate the podium.
Thank you. Sorry, you have to come up here to make sure you're on television. Yes, Mr. Hockman.
May it please you, sir, Stephen Hockman, instructed by DLA Piper on behalf of Arconic Architectural Products, SAS. May I begin by expressing our deep regret in relation to the occurrence of the fire, with all its consequences, including especially the terrible loss of life, and our deepest sympathy to the bereaved, to the survivors, and to all others affected. Our clients make clear in their position statement, in which we were invited simply to set out the role we played, that we supplied certain cladding materials to others, whose role it was in turn to fabricate them for the purpose of use at Grenfell Tower. We may not have been the only suppliers of such cladding material. We had not intended to lengthen this hearing by making submissions to you, but wanted now, as you've kindly assented to address you briefly, simply to make you aware that in relation to the oral submissions of Ms. Barwise, not foreshadowed in writing, there will be a significant issue. The issue will not be as to the fact that the core of the cladding supplied by us was not of limited combustibility. Clearly, that was apparent to those concerned. The issue will be as to the requirements of the regulatory regime and as to the accuracy of what you've been told that the regime requires. The use of material which was not of limited combustibility did not in itself give rise to a breach of the regime. To establish such a breach would involve considering a much wider range of factors. We don't intend to say any more at this stage. We would like the opportunity to see and consider the expert evidence, and having done so, we will address matters further in our opening statement, due a mere 6 weeks after receipt of what we anticipate will be many hundreds of pages of technical material. But in the meantime, we're very grateful for the opportunity to make this brief set of comments.
Yes,
Thank you.
Thank you very much. Thank you. Yes, Mr. Millett. Thanks.
Yes. I apologise to Mr. Sturman for not introducing him as I should have done. Mr. Chairman, on the list is closing submissions from me. Having heard the oral submissions this morning, I wasn't proposing to make any closing submissions to you. I would only do so if there was anything to clarify or to correct. What I would do is to clarify or correct perhaps two things, both of which were said by Mr. Seward. First of all, it is not right that we have a list of 108 firefighters ready to, as it were, call. That process, the process of identifying which firefighters we wish to call, is a continuing one. We certainly have not made any decisions, certainly not final decisions, as to who we wish to call and who we do not. We will only be making that decision when we have a greater body of firefighter statements reviewed by our internal team when they come in and as they come in, as we go. But I anticipate that that primary list will be ready in the near future. And we do take on board very much what Mr. Seawood said and indeed what Mr. Walsh said about the need to identify who those firefighters are at the earliest opportunity, if only for operational reasons. But there are other reasons, of course, as well. The other thing I should just say, having heard Mr. Seawood, is that we would strongly discourage the process that he advocated of having a meeting between the FBU and any relevant firefighter for what he anticipated would be the purpose of that meeting. Any taking of evidence from any firefighter must be done in public. This is a public inquiry, and in order to facilitate the full and effective participation of all call participants, a private meeting in that way would not be appropriate. But that is the inquiry team's position. In those circumstances, we think it right, Mr. Chairman, that you should give a ruling on that matter, and we would ask you to do that as soon as possible, so that everybody is clear about it. That is all I wish to say by way of closing submissions, unless there's anything further that I can assist you with, Mr. Chairman.
No, I think not. Thank you very much indeed. Well, that brings the hearing to a conclusion. I'd like to thank you all once again for the submissions you've made, both in writing and orally. I've been impressed by all the expressions of cooperation, which I've absolutely no doubt are sincerely made, and I hope that we can work with you in order to make the inquiry go forward in a successful way. Sometimes cooperation is best achieved by discussions between solicitors or counsel or whoever it may be. Sometimes it can be engendered by a more public meeting of this kind, but I'm sure that one way or another we can achieve that. I'm very grateful in particular to those representing the bereaved survivors and residents for having divided up their submissions in the way that you have, because there hasn't been a lot of overlap. I don't use the word repetition, it wouldn't be fair. But it does mean to say that the hearing can be conducted efficiently, and I don't get confused by three people making the same point in different ways. Anyway, thank you all very much. That's the hearing, the end of the hearing, which is now closed. Thank you.